Good evening, good afternoon, good morning to everyone joining for the signing and launch ceremony of the Indian Association of Litigation Finance. Thank you so much for such a wonderful response leading up to this day. We're very thankful to everyone who registered for this event on its first launch day of 7th January and its rescheduled day today. We have been fortunate to receive over 900 registrations, and that level of interest shows that India is ready for litigation finance. And this is the reason why members from across the fraternity have come together and founded this Indian Association for Litigation Finance. The agenda for today is to take you through litigation finance in general, how it works in India, the reason why IALF was formed, and how the IALF intends to proceed. We will cover these topics by taking various domain experts through their experience of litigation finance and putting challenging sometimes, but interesting questions to them of how litigation finance will be for the Indian market. For the people joining in from various parts of the world, please feel free to use the Q&A section in the bottom of your screen. We will try our best to pick up as many questions as we can at the last 30 minutes of the session. I know this is a signing ceremony, and if we were doing this physically, there would have been certain candles and certain lights we would have lit up with the papers being exchanged and signed. Unfortunately, COVID takes away those advantages, while it of course gives us the ability to have so many of you together at the same time. Therefore, I'm going to request you to take my word that the working group has signed the charter. While we are not able to display it due to COVID, we will circulate the signed charter to all the registrants to take a look and go through it. I, of course, intend to take the people attending today through this journey and dwell upon a little bit on what the working group is going to do and what the charter looks like. Seeing a lot of people have come in now, I would like to straight move in with today's presentation. As you may have seen in the schedule, the presentation will start with me giving an overview of litigation finance and IALF. We will then move to the industry perspective, where we have funders from across the globe giving their view on what they see in Indian market and how litigation finance will work for the Indian litigants. We then have adjudicators and institutions who will talk about their view on how they see litigation finance playing a role. Of course, several renowned practitioners who will then share their perspective of the market. Last but not the least, the experts who will give their perspective on what litigation finance means for the Indian market. But before we can start this journey, the important question is, what is litigation finance? And litigation finance can mean several things. In the most basic form, it is, of course, receiving cash to fund your litigation. Litigation can often be an expensive exercise. A lot of us from the industry are aware of this, and we are aware that sometimes it can get very challenging to cover the cost through the litigation. In the most classic way, litigation finance provides finance or money for the litigation. But that's not the end of the product. The product is pretty versatile. In some form, litigation financiers also act as general contractors. They bring in deep talent of managing disputes, high value commercial disputes, and taking them to resolution. Think of it as a project. Now, as a project company, you may have certain skill sets, but you may not have the skill set of tunneling. What you do at that time is you partner up with a tunneling expert who brings in the expertise to develop the tunnel with you. Certain litigation financiers act as these partners who bring in specialized capability of managing the litigation and taking their fees on success basis. While doing so, they of course even manage the cost of the litigation, providing that element of finance. Others also purchase or discount your debts. This is another form of interesting finance where receivables, especially in the form of awards and decisions, are directly taken over by litigation funders. In these testing times when liquidity is a challenge, such kind of deals helps creating not only working capital, but it deleverages already stretched books. Lastly, litigation financiers also bring in insurance. Today, we know that in disputes, especially after the amendments in the Indian Arbitration Act, cost follows the consequence. Similarly, when Indian parties litigate in arbitrations abroad or in litigations abroad, the rule is very natural that cost follows the consequence. In these situations, you may go into the litigation with a budget of a few $1 million, but you may come out losing with a bill of the other side's fees, which can sometimes go into multi-million dollars. A good example of it is investment treaty arbitration, where adverse cost sometimes runs into sevens and tens of millions of dollars. Insurance covers this downside protection, and that product as well is known as litigation finance. So as I said, there's a lot of versatility in the product, a lot of names. At the end, all of them individually or collectively are known as litigation finance. Now, when you talk about litigation finance in India, unfortunately, the immediate reaction is doubtful. There isn't enough market awareness of the concept, and that leads to a lot of people questioning it as illegal or against public policy. Respectfully, this is without basis. Indian law has very deep roots in litigation finance. A lot of us would be surprised to know that one of the oldest decisions of litigation finance comes from India in 1878. And this is because, unlike most of the common law countries where champity and maintenance were adopted, in India, these special laws were never found to be of force. The main reason was champity and maintenance had Christian roots coming from Britain, and India in the provinces followed Hindu and Muslim law, which did not have a problem with financing someone else's litigation or maintaining someone else's litigation. And therefore, champity and maintenance never got adopted. With this, Indian law actually was ahead of other common law territories. And the history and richness in Indian jurisprudence is not only appreciated by Indians, but by several other courts across the globe. One recent example is the Supreme Court of Queensland in Australia, when they recently, in the Gladstone Ports case, were discussing the validity and legality of litigation finance, and they cited this first judgment, which went up to the Privy Council of Ram Kunur Kundu. So therefore, the concept here is that a fair agreement to supply funds for a return has been lawful in India since at least the 16th century. And it has been ruled to be applicable till 2018 by the Supreme Court in A.K. Balaji. So when people say there is some sort of illegality or litigation financing against public policy, I would beg to differ on the basis of this depth of jurisprudence in our law. Of course, there is a requirement of the litigation finance agreement to be fair. And a fair agreement is an agreement which is not improper or is not extortionate and doesn't violate public policy per se. Now, of course, this is subjective of what is fair, but the jurisprudence has given guidance. And if someone picks up and reads through the 100 years or 200 years of jurisprudence in India, they will realize soon that Supreme Court has, or the other courts as well, has really laid down several guidelines on what is a fair agreement. One such unfair agreement is, of course, pure gambling in litigation. What is this pure gambling in litigation? It is funding something which is improper. On the face of it, you know it's a baseless litigation, but you're promoting that with a chance of return. That has been held unfair by the court and set aside. Similarly, if the lawyer funds the litigation under Indian law, that is something which is not permitted. The lawyer is not allowed to be on contingency. The lawyer is not allowed to have a conditional arrangement on the outcome of the litigation. Those arrangements makes the entire litigation funding agreement in question. And it has gone through the threshold of a few courts in India who have confirmed this time and again. Similarly, having influence on the decision maker. So if the financier influences the decision maker, Indian courts have ruled such agreements to be against public policy, which again is something reasonable, because if you have economic interest in the case and you are controlling the decision maker, it may not be a fair assessment of the case. Lastly, of course, in certain cases, when the financiers have misled the claimants about the cost, the courts have found these agreements to be invalid. Closely connected to this is the assessment of commercial value. The courts have required funders to assess commercial value in advance. This includes assessing the claim in detail and coming to a reasonable conclusion on the success of the case before investing it. There are several such other grounds where the court has recognized the funder to have an uplift, has allowed the funder to control the litigation, and so on and so forth. Today, litigation finance is growing in India because there is growing trends to promote international litigation. This includes amendments to various laws which bring in speed, such as the Arbitration and Conciliation Act. There's also one more reason is the growth of international disputes, which is through arbitration and cross-border litigation. Mass claims, of course, is something which is coming to India, especially with the growing bank frauds. You have the insolvency regime, which has improved. You have global enforcement and debt recovery provisions available. And with this, there is a growth of trend and focus on litigation finance in India. And with this focus, of course, with this growth of industry, we have today come to the IALF. The Indian Association of Litigation Finance intends to create a circumstance in which litigation finance can grow in Indian market. It tries to create a level playing field for the funders, the lawyers, the experts, and the clients using litigation finance. It tries to self-regulate certain critical items like when can a funder withdraw from a case, how much solvency the funder should have, what should be the origin of capital for the funder, how much control should the funder have on a litigation, what conflict rules the funder should follow, and what confidentiality rules the funder could follow. There could have been a few ways to regulate this, either through a statutory method or the way we are currently doing it through ad hoc judgment. But the members of IALF feel that self-regulation, at least for the sophisticated market, is a good choice. We've seen something similar in UK. Of course, for the unsophisticated market, and especially for the mass claim, there may be an outside third party which will play a supportive role for certain critical items like source of funds or conflict of interest. But IALF also aims to be a body which will be a single point to have dialogue with such regulators and enable them to come up with dynamic regulations fitting to the international market needs. Just to quickly take you through the structure of IALF. IALF will comprise of members from across the segments of dispute resolution, including institutions, adjudicators, funders, and lawyers, experts. The membership will open once the working group in front of you comes up with the relevant instruments applicable to IALF. These instruments will include an article of association, rules of governance, code of conduct, guidelines for funders and institutions, and procedure for dispute resolution between clients and funders. Once these instruments are made, the working group will also appoint a board of director, the dispute resolution board, the CEO, and the chief disciplinary officer. And with these will lay foundation of the IALF. The IALF then intends to be both a self-regulating body and educating body. It intends to be a one-stop shop for people to discuss, learn, and thrive in the business of litigation finance.